prepare it with confidence. So in terms of the agenda for today, so you're going to be meeting all of the employment team members who will be presenting today. And in terms of that agenda, so Abby will be taking us through the changes that already came into place in April this year. Then Caitlin will be talking us through the changes on the horizon in October this year and into 2027. And then we'll be handing the baton over to Sam, who'll be talking us through the biggie coming in January 2027. And that's the changes to unfair dismissal law and how we can manage probation periods. And then we'll be finishing up with Mike, who will be taking us through some practical observations around how to manage exits and settlement discussions in this new era. So in terms of questions, feel free to submit them on the Q&A box. And we are going to be recording today's session as well. Hopefully we'll be able to create a recording after the session to share. So without further ado, I'd like to hand you over to Abby. Thanks, Abby.
Thanks, Sarah. So as Sarah mentioned, some of the changes we've seen from April and in general in the Employment Rights Act, some of the biggest we've seen in a generation. And whilst there is still a way to go, from the 6th of April, we have seen a number of the key changes come into force, and I'm just going to guide you through a recap of some of the changes we saw in April. So firstly, the Act now prescribes paternity leave as a day one right. Previously, eligibility for statutory paternity leave required employees to have been employed for 26 weeks, which was assessed 15 weeks before the expected birth. This change means that expectant fathers can now give notice of leave from the first day of employment. So whilst this is quite a progressive change, it is important to note that this only applies to children born on or after the 6th of April 2026, children whose expected week of childbirth is on or after the 6th of April but are born early, and adoption placements on or after the 6th of April. The service requirement for statutory paternity pay, which is currently 26 weeks, remains in place. New employees can take paternity leave, but unless your company policy says otherwise, the leave would be unpaid. Whilst the government wants to ensure employees are covered by a baseline of rights, it's so far been reluctant to place the burden of any extra costs onto employers. Notice rules haven't changed either, so employees still need to give notice of their entitlement by the 15th week before the expected week of birth, then confirm their choice of specific date 28 days in advance. New joiners who can't meet these deadlines must give as much notice as is reasonably possible. The restriction on taking paternity leave following a period of shared parental leave or shared parental pay has also been removed by the Act, meaning that employees can now take paternity leave and pay even after a period of shared parental leave. I just want to touch briefly upon the parental leave actually. So the new Act prescribes that ordinary parental leave or unpaid parental leave is now a day one right. So previously, someone must have worked for their employer for 1 year in order to be eligible. In practice, generally, uptake of parental leave is quite low, and historically this is the case, and we're not really expecting this to change even in light of the new changes. The final point here then is the introduction of a new category of extended paternity leave for parents whose partner dies during childbirth or within the first year of the birth. This is called bereaved partners paternity leave. So eligible fathers and partners are able to take up to 52 weeks of unpaid bereaved partners paternity leave if the mother or primary adopter dies. The leave can be taken in one block and there is no minimum service requirement. If leave starts within 8 weeks of the bereavement, employees can start leave immediately on oral notice only. However, as there's no statutory entitlement, pay is completely at the employer's discretion. Moving on then, changes have also been made to the statutory sick pay regime. So before the 6th of April this year, statutory sick pay was payable from the 4th day of sickness absence. However, the new reform means that statutory sick pay is now paid from the first day of illness. The lower earnings limit has also been removed, meaning that all eligible employees, regardless of their earnings, are now entitled to statutory sick pay. Those earning less than the lower earnings limit, which is currently £123 a week, are entitled to statutory sick pay, and this will be at a rate of 80% of their weekly earnings. Various proposals were initially made to strengthen whistleblower protections within the Act, However, the only whistleblowing related provision to have survived the parliamentary process is the amendment of the definition of a qualifying disclosure. The amendment means that sexual harassment is now a qualifying disclosure, meaning that whistleblowers making a disclosure that sexual harassment has occurred, is occurring, or is likely to occur in the workplace will have protection from detriment and unfair dismissal. Another change we've seen in April was the establishment of the Fair Work Agency, which is the new executive agency of the Department for Business and Trade. This new agency has powers to bring together existing enforcement bodies to enforce specified labour market legislation. Provisions mean that eventually the overall aim of the Fair Work Agency will mean they have the power to enter premises and obtain access to documents, information, records, and policies, the right to enforce labour market and employment rights in the workplace, whilst also giving notices of underpayment, and also the power to create criminal offences relating to enforcement. So far, the agency has already taken over enforcement of areas such as employment agency regulations, gang masters licensing, and modern slavery and labour abuse rules. It's also taken over national minimum wage enforcement. However, it will be using the existing HMRC enforcement team for this until around April next year. It is also intended that holiday pay enforcement will fall within the remit of the Fair Work Agency, with enforcement set to commence in 2027. No specific date has been set as of yet. One point that does remain unclear, however, is whether the agency will take over statutory sick pay enforcement. So next then we have the Collective Redundancy Protective Award. So from the 6th of April, the maximum protective award for failure to collectively consult in a collective redundancy is now 180 days. This is an increase from the previous 90 days pay. It's quite important to note here that these provisions do not apply in relation to dismissals taken effect before the 6th of April 2026. So the increase to the protective award makes the cost of non-compliance with collective consultation obligations significantly more expensive for the employers. The award is now double. So this is therefore more high risk for employers too. This increase in pay will now likely lead to employers having to review their internal policies and approval processes for proceeding with proposed collective redundancies, and upskilling HR and senior managers through training on collective consultation obligations. Next, also from April, employees of all sizes can voluntarily publish action plans around gender equality, specifically matters addressing the gender pay gap, as well as supporting employees going through the menopause. And whilst employees are encouraged to report on a voluntary basis, it is intended that around April next year, 2027, reporting will become a mandatory requirement for all employers with 250 or more workers. So the way in which trade unions can be recognised in a workplace has also been simplified from April this year. Some of the key changes worth noting are as follows, but this is not an exhaustive list. Just a few important points: that mandates for industrial action are increased from 6 months to 12 months. Unions must give employers 10 days notice of industrial action, whereas previously the notice period was 14 days. These are calendar days, not working days. Unions no longer need to tell employers in advance how many workers in each role may strike, and members simply vote on the action they wish to take, either strike action or action short of a strike. An updated code of practice on trade union recognition supporting these changes is expected to come into force in October 2026, in a few months' time, but more is to come on that front. So the final change then brought into force from April was the obligations for employers to keep records of annual leave and holiday pay. The manner in which records should be kept isn't actually specified by the Act, which does give employers a degree of flexibility in how they wish to store the information. However, it's important that any records kept must be complete and accurate, and the information must be kept for at least 6 years. So, in light of the changes that are now in force, we've compiled a few action points for employers to bear in mind, just to ensure that you're staying ahead in respect of compliance, but also in preparation for the changes to come. So firstly, we would encourage a review of workplace policies to reflect the changes. So for example, your whistleblowing policy, sickness policy, parental leave policies, keeping these policies up to date and robust, and making sure that these policies are visible to employees at all times. Secondly, let your managers and leadership teams know about the changes so that they're fully briefed and able to deal with any employee queries. And finally then, we would encourage you to check any payroll systems and HR record keeping forums to ensure that they're compliant with your obligation to keep statutory sick pay, annual leave and holiday pay records. So that concludes my whistle-stop tour of the changes brought about in April. I'm going to hand over to my colleague Caitlin, who will take you through the changes that are on the horizon. Thank you.
Thank you, Abby. That was really helpful. Can you all hear me okay? Yeah? Great. So I'm going to run through some of the employment law changes that are due to take place in October of this year. And we're going to start with a duty to prevent sexual harassment. So as of October, employers will be required to take all reasonable steps rather than the current requirement to take reasonable steps. So it's going that bit further to prevent sexual harassment of any employees in the course of their employment. Legislation will also be amended to enable the government to make regulations specifying the reasonable steps an employer should take, or the steps an employer has failed to take to prevent sexual harassment. Now, the government has stated that it will consult on what the new regulations should specify with regards to what exactly amounts to reasonable steps, once it has considered the responses to a recent call for evidence. It is understood that what constitutes all reasonable steps will depend on the specific circumstances of the employer, such as their size, sector, working environment, resources, and other relevant facts. However, it is worth noting that the regulations specifying what amounts to reasonable steps are not anticipated to come into force until 2027 following consultation. The duty to take all reasonable steps to prevent sexual harassment of employees will be an onerous one for employers. It will be much harder to successfully defend a sexual harassment claim, and employers will face both the financial penalty of an uplift to the employee's compensation and a potential investigation by the Equality and Human Rights Commission, resulting in enforcement action. So we are anticipating the guidelines, like I said, specifying what amounts to reasonable steps. So we'll keep our eyes peeled on that and update you accordingly. We've also on the slide got the mention of harassment in general, a third-party harassment. So as well as this new duty concerning sexual harassment, again, from October this year, employers will also be under a duty to take all reasonable steps to prevent third-party harassment in relation to all relevant protected characteristics. So that includes harassment from clients, customers, suppliers, etc. And then if we could go to the next slide, please. Thank you. So on this slide, we've got the mention of trade unions. So we will have some changes coming into effect with regards to trade unions, and there are quite a number in this respect. So the first change that I'm going to address concerns a right to a statement of trade union rights. So this will require employers to give workers a written statement advising that they have the right to join a trade union. So the statement must, number one, be given at the same time as providing the worker's Section 1 statement or terms of employment, and number two, at any other prescribed times, which will ultimately be set out in secondary legislation. In October, trade unions will also have a new right of access. So essentially, new provisions will enable trade unions and employers to enter into access agreements for union officials to access an employer's workforce for various purposes. The union will present what would be known as an access request, which may request access on one or more occasions and propose terms for that access. And that request will be submitted to the employer, who will then issue a response notice to the union before the end of the response period. Assuming, of course, the employer responds, the parties then have the negotiation period to agree written terms on what the officials will have access to. An application to determine a union's access may be made to the Central Arbitration Committee by the union if the employer fails to respond to its request or where negotiations are unsuccessful. So, like I said, the union have that option if the employer doesn't respond. The committee will then determine applications taking account of the access principles and will also determine alleged breaches of access agreements or prevention of access by a third party. And ultimately, any appeals on points of law from committee decisions will lie with the Employment Appeals Tribunal. So there's a lot to come out in terms of what those access principles will be and what that will look like, and we await further guidance on that. Trade unions will also, as of October, there'll be a new provision, meaning that where an employer permits an employee to take time off during their working hours for the purpose of carrying out trade union duties, they must also provide the employee with such accommodation and other facilities for the carrying out of those duties or where they are undergoing training. In addition, a new right will be introduced to allow an employee to complain where an employer has failed to provide them with such facilities. These new rights will also apply to trade union learning representatives as well, so just a little note there. Currently, there is guidance which gives examples of accommodation and other facilities, taking into account an employer's size, resources and organisational structure, but we are waiting on further confirmation of what this will look like in practice from the government. And then another change that's mentioned on the slide, which isn't related to trade unions, concerns that of tips. So as of October this year, the Employment Rights Act will be amended to require employers to consult about their initial written tips policy with trade union or workers' representatives, or directly with workers when none exist. Employers will also be required to review and consult on their tips policies at least every 3 years and provide an anonymised summary of the consultation responses to workers. And then if we could go to the next slide, please. So we also have some employment law changes coming into effect in 2027. We're not sure exactly when, but they are anticipated. So I will run through those with you now. I will skip the unfair dismissal note on the slide as my colleague Sam is going to come on to talk about that shortly. So if we go through the other changes mentioned on the slide, we've firstly got the one concerning fire and rehire. So in January, there will be changes to what is often termed fire and rehire practices. Now, in other words, dismissals and re-engagements. So the Employment Rights Act will be amended to make it automatically unfair to dismiss an employee for refusing to a specific contractual change in their contract of employment, or to enable the employer to employ another person or re-engage the employee on varied terms. Furthermore, the Employment Rights Act will be updated to make it automatically unfair to dismiss an employee to enable the employer to replace them with a non-employee. So, for example, an agency worker or a self-employed contractor. However, there will be an exception where an employer can demonstrate genuine financial difficulties and that the business could not continue as a going concern without implementing the specific contractual changes. There will also be some changes concerning collective redundancy consultations. So currently, legislation provides that where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, that the employer is required to collectively consult with respect to the redundancies and notify the Secretary of State. However, in 2027, legislation will be updated to introduce an organisation-wide threshold so that, as an alternative to the existing establishment threshold, the obligations to collectively consult and notify the Secretary of State of collective redundancies will be triggered if an employer is proposing to dismiss as redundant at least a threshold number of employees across its organisation within a period of 90 days or less. It is anticipated that the government will make regulations specifying the threshold number of employees, which must not be lower than 20. The threshold number may either be a specified number, a number defined by a particular percentage, or a combination of the both. So we will have to wait to see what the government decides on this point. At some point in 2027, there will also be some changes to the rights of pregnant workers. So the Employment Rights Act 2025 does grant powers for the government to make regulations relating to dismissal for reasons other than redundancy during or after a protected period of pregnancy. The government has previously indicated that it will use these powers to make it automatically unfair to dismiss a pregnant employee or new mother until she has been back at work for at least 6 months after their return, or save for in specified circumstances. So we are waiting further information on that matter. It's quite unclear what that will entail at present. We've also got the mention of flexible working on the slide. So in 2027, employers will be able to refuse a flexible working request only if it considers that one of the statutory grounds applies and it is reasonable for them to do so. An employer must also notify the employee of the ground for refusal and why it is reasonable to refuse on that ground. So consultation will be required. We've also got mention of 0 hours. So in 2027, it is expected that new rights for agency workers will come into force with respect to 0-hour working. Essentially, it is anticipated that the protections currently afforded to 0 hours and low hours workers against one-sided flexibility will be extended to agency workers. The protections will essentially entail a duty on employers to, number one, offer guaranteed hours contracts, number two, provide reasonable notice of any shifts, and number three, to pay compensation for cancelled, moved or curtailed shifts. So duties will be more onerous on employers in that respect. And then we've also got bereavement leave. So again, at some point in 2027, unclear when, but it is expected that the government will make the existing right to 2 weeks parental bereavement leave a day one right, and that leave will be extended to be a more general bereavement leave with an entitlement of at least 1 week. What I mean by a more general bereavement leave is that it will essentially apply to the loss of a wider group of persons, which will be specified in regulations, and we haven't got any detail on that at present. But it's anticipated that it will include workers who suffer pregnancy loss before 24 weeks. Now, statutory parental bereavement pay will continue to be payable where a child under the age of 18 has died, but provision at the moment hasn't been made for the wider class of bereavement leave to be paid. So we do need to wait to see whether or not bereavement pay will be extended to that wider group of persons, which is yet to be specified. Ultimately, to take away from this, it will be a case of, in time, updating relevant policies. So, for example, flexible working policies, any bereavement leave policies, nearer the time once the changes have come into effect and we know exactly what the new regulations will entail. And we can, of course, assist with that process. So please get in touch in time. Alternatively, of course, we will update you via our newsletter of any changes and what exactly they entail when they come into effect. So I'm now going to hand over to my colleague Sam, who is going to run through some unfair dismissal changes with you all.
Thank you, Caitlin. Can everyone hear me? Maybe someone just give a thumbs up just so I can, just so I know that it's all good. Okay, thank you, Caitlin. So yeah, I'm going to cover unfair dismissal. Well, me and Mike are. It's kind of the biggie. I think I'm quoting Sarah here. So no pressure for us, Mike. So let's see how we get on. So I'm going to cover the new changes plus some brief points regarding the impact and importance of probationary periods given the shorter service period. I'm also briefly going to discuss last-minute dismissals and the pitfalls of statutory notice. And to help with that, I'm going to look at a scenario that I've prepared, which I think will be helpful for these purposes. So before I get into it, I think it's possibly worth having just a very quick, very brief update or recap of what the current law is. So at the moment, the current qualifying period to claim unfair dismissal is 2 years. You need to have 2 years of service. And also, if you bring a claim at the moment, there are two elements of your claim. There's the basic award that a tribunal can award and something also known as the compensatory award. The compensatory award at the moment is subject to a cap of £123,543 or 12 months gross pay, whichever is the lowest. And it's worth remembering that tribunals will assess the compensation on the basis of actual and projected losses and what is just and equitable. The changes that are coming into effect won't affect these fundamental principles, which I think I've set these out on the slide. So from the 1st of January 2027, the qualifying service period will drop to 6 months, and the cap on the compensatory award, I almost said reward then, will be removed altogether. So you can appreciate these are some quite fundamental changes, as Sarah said, the biggie. It's also worth emphasizing, I think, that these are likely to remain for the long period, because I'm not going to get into the technicalities, but essentially the government has made it very difficult to change the qualifying service period very quickly, as they were previously able to do so, and similarly with the cap, or the removal of the cap. So that means that in short, the changes are likely to stay. Just by way of estimate, the government is estimating that the change will lead to around 9,000 additional ACAS early conciliation notifications each year, leading to roughly 3,000 tribunal claims, which obviously is quite a lot. Some people think this is a rather conservative estimate. So yeah, sorry, I'm leading with the positives here, but there are some positives that I want to highlight as well, maybe, just so it's not too gloomy. So yeah, you can see on the slides, I'm not going to go through everything on the slides. A lot of it is there for informational purposes. So yeah, I won't refer to everything because you'll see that there's a lot of bullet points. So Abby, can you go to the next slide, please? Thank you. So what remains unchanged? So I mentioned at the beginning about the tribunal awards. It's also worth emphasizing that most of the compensation awards in reality are expected to remain below the previous cap, let alone an uncapped regime. So there's quite limited statistics about this from the tribunal, but from the most recent that I could find, the mean award for unfair dismissal was around about £14,000. So you'll appreciate that's significantly below 123,000. So that won't change despite that. So I guess that's possibly a positive to think of. Something I want to go into very quickly is just about fixed term contracts. I think possibly Mike might cover this, so I don't want to steal too much of his thunder. But effectively, what I want to emphasize is that, and this has always been the case, but the non-renewal of a fixed term contract in law is a dismissal. Now, previously, this was less of an issue because there was kind of a 2-year buffer. But what it means is once a fixed term employee has 6 months service, once again, the employer in this situation will need to dismiss for a potentially fair reason. So one of the 5 reasons: capability, conduct, redundancy, some other substantial reason, or statutory illegality, and also follow a fair process. Now, usually in the case of fixed term contracts, most of the time, absent any performance or conduct issues, it's normally going to be either a redundancy situation or some other substantial reason. But of course, what I would emphasize is it depends on the circumstances, and it's important to document and to be proactive in terms of communicating if a fixed term contract is going to end, what the purpose of the fixed term contract is. So for example, is it maternity cover? Is it for a time limited project? If it's for either of those 2 scenarios, then it's likely that you could rely on some other substantial reason as your fair reason. But you would have to follow a process, so you would need to communicate with the employee and other things like that. If it's performance related, then you can manage through a probationary period, which is something I'll cover in a little bit. And then redundancy, again, the general principles would apply. It's only applicable where the requirement for the work has genuinely reduced or disappear. And in that case, you would follow the normal principles, including thinking about the appropriate pool, engaging in consultation, and considering suitable alternative employment. I think something I want to emphasize as well, just while I remember that just because someone qualifies for unfair dismissal does not mean that they will be successful if they bring a claim. They may still well have a very weak claim. And I think it's always important to remember that. It doesn't mean that you won't be able to dismiss someone for a fair reason, as long as you have one and you have your paperwork up to date and you document if you meet with them and if you express any concerns about things like performance. I think Mike is maybe going to cover this in his slide, so I'm not going to go into this in too much detail. But I think, oh, actually, sorry, I've skipped ahead to the next slide. Sorry, Abby, could you go to the next slide, please? Sorry. Perfect, thank you. So what I was going to say is, I've kind of skipped ahead there as Scott talked about the fixed term contract. What is also worth mentioning is because of the change, the removal of the cap, high earners now are more likely, there's less incentive to settle because previously they were subject to the cap. It also potentially brings into someone who has a modest salary but a significant pension, and they're at the end of their careers, that could be potentially challenging if you dismiss them without a fair reason, because if they're at the end of their career, they may be able to pursue career long loss. So we think in reality, what is going to happen is there are likely to be more complex remedies that individuals seek as part of compensation. So the type of thing I just mentioned, so pension loss, career loss, that previously would have been subject to the cap. I've mentioned the point about high earners. Potentially, one of the positive impacts, I guess, could be that whistleblowing and discrimination claims may decrease, because as you're probably aware, these claims at the moment are uncapped, and therefore it means that there's less incentive going forward for employees to try and pursue spurious whistleblowing or discrimination claims, which are more time consuming for tribunals because they require more listing times. Sorry, that's probably the best I can come up with in terms of positives for now. Okay, can we go to the next slide, please, Abby? So if you remember, I mentioned about statutory notice and about it's kind of a practical scenario, a practical demonstration of the changes. And it's also kind of a warning against the pitfalls of last minute dismissals. So in this case, it involves a fictional individual. It's not me at all. So Sam joined Berry-Smith on the 1st of July 2026. Berry-Smith decides to terminate Sam's contract on the 29th of December 2026 and effectively to pay him in lieu of his 1 month notice period. But because Sam has received a payment in lieu of notice, now note this scenario is not applicable for individuals who are dismissed without notice, the law will add an additional week of notice. That means that the termination date for these purposes is not the 29th of December 2026, it's the 5th of January 2027. That therefore means that Sam can bring a claim for unfair dismissal because of the operation of statutory notice. But I guess on the positives, the compensation would be capped because the dismissal occurred before the 1st of January 2027. The other point relates to the statutory notice brings forward your length of service by a week, but it doesn't affect your entitlement to bring an uncapped claim because that relates to when the dismissal took place. And that would have to be after the 1st of January 2027. So that's just a helpful scenario. I think what I'm trying to emphasize here is don't think that you are safe if you dismiss someone at 5 months and 3 weeks, because there is still pitfalls. Statutory notice could tip them over the edge. So yeah, and like I said, just because you do have unfair dismissal protection does not necessarily mean that the individual is actually going to be successful with their claim. Next slide, please. And now to wrap up, I'm just going to talk about probationary periods and how these should change. So previously, I think employers have generally relied on a sort of longer open-ended probationary period as a buffer because the qualifying service period was previously 2 years. Now, I think given the changes, we suggest that you reconsider the length of probationary periods and actually to consider them for all roles, because I know at the moment it's unusual for senior employees to have probationary periods, but we think that given that protection is going to kick in earlier and also the uncapped element, we recommend that you bring that you change your probationary periods to reflect that. So as a general rule of thumb, we would say it's probably better now to set it at about the 3 to 4 month mark, because that gives you enough time for the person to come in, for you to genuinely measure their performance, and you can screen and ascertain really whether they are an appropriate fit for the organization. What's crucial though during the probationary period is to make sure that you are setting clear, measurable targets. And really what it means is you need to be on top of this. I think possibly, if anything, this may be another positive, is to make sure that you get your house in order and make sure that probationary periods are used to their full extent. So set specific, measurable, achievable targets, and make sure to organize review meetings during the period, just to check that they are actually meeting the objectives that you've set. I think it's also important, I think Caitlin or someone mentioned about contracts and changing contracts. It's also important to include within your contracts of employment the opportunity to extend the probationary period, and extend it if necessary by an additional month if there are any concerns. Now, the good news is we don't think that it's necessary during this initial phase for you to engage a full-on performance improvement plan process like you would after they reach, say, 2 years service. Like now, you don't have to engage a full performance procedure, but you will need to. It is good practice to have a light touch process where you set out in writing your concerns, you invite them to a meeting, you let the employee, you put the case to them, you let them respond to any representations, you go away, consider what they've said, and then you write to them again. And just to check, I think it's very important to document concerns during any check-ins. Make sure to prepare attendance notes, even a brief contemporaneous email or file note, which is clearly date stamped, is better than nothing. And at the end of the day, what the tribunal is going to look at is the reason for the dismissal. Now, normally in a probationary period, this will be capability. So it's important that you have evidence to that effect. And if they were to try and bring a discrimination claim, for example, you can clearly evidence that it was not for a discriminatory reason. And I think to close, can you go to the next slide, please, Abby? One other point I should have mentioned at the end was just in relation to, I think it's better to set out that you will confirm in writing that the probationary period ends. Don't just let it lapse, as it were. I think that's important. And set out, normally this would be set out in the contract of employment. It will say words to the effect of, your probationary period will continue until you are informed in writing. And to finish up, I've just got a very brief illustrative example of what your sort of probationary period structure may look like. It's an illustrative example. I haven't gone into depth, as you can see, but it's just the kind of considerations that you might want to consider. I've sort of done it on a 4-week interval. At week 12 or after week 12, you may then wish to consider if you want to extend the probationary period for an additional 4 weeks. But really, I would say when you get to around the 8 weeks marks, I mean, I don't want to set this in stone. Obviously, it depends on the circumstances, but you really need to be monitoring performance. Are they developing as expected? Are objectives being met? If not, is any additional coaching or support required? Document if the employee thinks that they would benefit from specific training mechanisms or support. And then, are there any targets to meet? If so, let them know and write it, let them know during the meeting, formalize that in a document. And then, if they are subject in that sort of final week 12 to any targets, are there any outstanding concerns that you have? I think at that stage, you might want to look at, are they on track to successfully complete the probationary period? If not, let them know that you are minded to extend probation, and this will be their last chance to improve, essentially, and maybe some targets and ways to improve. So that was my attempt at a whistle-stop tour. I don't think I've gone horrendously over the time, which is incredible, because I thought I was going to really badly exceed it and steal all of Mike's points. So with that, I'll kind of bow out and I'll let Mike take over then.
Brilliant. Thank you, Sam. And no, you've certainly not stolen my thunder. There's a lot to live up to. But what I will be doing is just covering some of the further practical considerations for employers. So firstly, I'm going to look at settlement agreements, the implications that the changes to the law might have on settlement agreements, key risks to employers, and key actions that employers should be considering making now to be ready for those changes, and in particular that unfair dismissal qualifying period and removal of the compensation cap in January 2027. So firstly, settlement agreements. And as many of you will know, a settlement agreement is a legally binding agreement by which usually an employee leaves in return for a sum of money, and they agree not to bring claims against the employer. And they can arise in cases of dispute, or often simply where the company wishes to avoid a lengthy process, and they go straight to a negotiation. The removal of the compensation cap could have quite significant implications, as Sam touched upon. And the first of those is when negotiating with high-paid senior individuals. And employers will often now think, right, we'll cut straight to the chase. We will start negotiation. If this person thinks they can challenge the decision, or they can bring an unfair dismissal, well, that's fine, because they can only claim 123,000, which is the current cap. So an employer might think, well, we'll only follow we won't follow any procedure. We would just say, we'll offer you 123,000. You can't claim any more. And what is the employee supposed to do? But with the removal of the cap, those individuals could make more significant settlement demands. And Sam touched upon this, but they could be looking for enhanced payment. So it's not just salary they're looking for, but they also would say, well, I've lost a bonus if I take the settlement, or if you dismiss me, I've lost share options and also potentially pension. And previously, the way the cap worked is that you could only claim salary, bonus, pension, whatever it might be. You can only claim up to a maximum of either 1 year's salary or the 123,000, whichever is lower. But as things go forward, that won't be the case. So if you take the example of an employee who is on, say, 250,000, they've got a 50,000 bonus, and maybe they've got share options for 50,000. Currently, they could only bring a claim still for 123,000. So the employer says, I'll give you 123,000. You can't get any more than that anyway in an unfair dismissal claim. Now, clearly that risk goes much higher to some, say, in this situation, 350,000. So they will be making higher settlement demands, because they would say, well, if you don't reach a deal, you have to go through a process to dismiss me. If that's the way you want to go, you won't be able to dismiss me. And if you do, it will be unfair. So I want a lot more money. And Sam also touched upon the career loss argument. So if, for example, you've got an employee who is nearing retirement, maybe, or a few years off it, currently the employer says, here's a settlement. Again, the max you can get in a tribunal, even if it's unfair, could be, it would be a year's salary, ignoring any potential claim for age discrimination. But an unfair dismissal, it would be a year's salary. Now, employees might now say, well, there's no incentive for me to go for a year's salary, because I might struggle to ever find a job again. And if I go to the employment tribunal with an unfair dismissal claim, I could stand to get losses up to pension age, and even potentially that will impact on any pension awards. So approaching these settlements could be a lot more difficult. And what leverage then does an employer have in these situations? Well, a lot of the leverages are the same as they currently are, but I think the key thing that an employer will need to ensure is that before going into a negotiation, it needs to ensure it has a strong, open process before it approaches settlement. For example, we would suggest you start, whether it be a redundancy process or a performance process, you maybe start that process, or at least you have detailed factual information to back that up, why there is a need to go through that process. So then if the employee does not accept a settlement offer, you will say, okay, well, that's fine. We will fall back on our open process and we will go through it, because we've already established that we've got a fair reason to do so. So you can say to the employee, yeah, you could say you'll get more money in an employment tribunal, but actually we're doing everything properly. So you're you're not going to have an unfair dismissal claim at all. This has always been our approach to settlements, if we're honest anyway, but I think the importance of that and setting out, making clear you have an open process becomes more important. And there are other leverages which are the same as now. So, for example, the employment tribunal system is a mess. There's so much backlog in that system, especially in the London tribunals and Manchester. And we've seen some of these recently where you could, if you're an individual, you could be waiting 3 or 4 years for a final hearing to take place. So an employer could say, yeah, again, you could take an unfair dismissal claim, but actually I'm offering you some money now. You're otherwise going to be waiting 3 or 4 years. You've got a duty to find new employment during that time. So there's no guarantee you're ever going to get that maximum compensation that you're looking for. And there may also be arguments such as the employee has contributed to any dismissal, or the Polkey principle that had a procedure been applied, there would have been a dismissal anyway. So there are still leverages, but as I say, I think the key one is to ensure that there is a basis to go down an open process if the settlement fails. And that leads on to that question at the end of this slide is, well, should employers then settle now rather than waiting until January 2027 when it might become a lot more difficult? And the answer could be yes. It might be sensible to take advantage of that current compensation cap, particularly for high earners. So I'm not outright saying if they're a problem, get rid of them now, but it's not a bad idea to start thinking of that, because it could make things a little easier if it's done sooner rather than later, certainly before January 2027. So that's settlement agreements. I'll move on to my next slide, which is concerning the risks that employers are facing with the change in the law. And I think Sam has touched on a couple of these anyway, really. So I'll just whiz through those. But the removal of the compensation cap, the reduction in the qualifying period to 6 months, it's going to have a significant change on the landscape for employers. The key shift is that risk crystallizes much earlier. An employer effectively has a much shorter window before unfair dismissal rights apply, and so they have a little less flexibility as to when they can, for example, say he's not working out, let's get rid of him. It's not going to work for as long. And as Sam's already been through, and I won't repeat all of it, but that does make probationary periods absolutely critical. And my guide to that is essentially set clear expectations at the outset of what is expected of that individual, monitor their performance closely, document any concerns and conversations held with the individuals, and act decisively if issue arises. You don't want to be in and then get into just before the 6 months and you think, oh no, we're in that final week, and then notional notice kicks in and people can bring a claim, which is something Sam covered with his scenario. So you need to get your probation period right. But another risk that we often see already, but is another risk going forward, is flaws in documentation. Bad documentation will be a problem in far more cases with the unfair dismissal qualifying period reducing to 6 months. And we would already say that documentation is critical, but we can understand that employers might think, oh, such and such, they're under 2 years service, let's just get rid of them. They haven't got any claims. But now, obviously, under 2 years, as long as it's over 6 months, you can't take that approach. So flaws in the documentation, which cover, say, performance concerns, conduct concerns, if the processes aren't good, that could have catastrophic impacts and consequences, because a greater number of individuals be affected and a greater number of individuals can pursue an unfair dismissal claim. And then finally on that side, I've got manager capability, which is potentially a major risk. And you often see unfair dismissal claims succeeding, not because the decision itself was necessarily wrong, but due to poor handling of the process or a lack of process completely. And again, employers might think now, we don't need to worry too much, because if they're a problem under 2 years, we'll get rid of them. But that's not going to be so straightforward. So if managers don't know the processes that they have to follow after 6 months employment, and even with those probationary periods, to make sure they're right, so that just over the 6 months, if there's a problem, you may be able to rely on that probation period. It's a big risk. So ultimately, the focus shifts from reacting to claims towards proactively managing risk much earlier in the employment lifestyle. So that takes me on to, okay, what key actions should employers be taking now to try and minimize and hopefully eliminate those risks? But bearing in mind that eliminating risk entirely is difficult when people can always bring spurious claims. So firstly, there with these 6 boxes on the screen, firstly, be very cautious again with last minute terminations, particularly around key dates. As we saw in the earlier example, timing can directly affect whether an employee qualifies for protection. If you have strong structured probationary periods, you know of the issues early on, and you can make a reasoned and decisive decision as to a person's suitability, which could be in 4 months, but then even if you extend it, maybe you're in month 5, you can still then make a decision as to that person's suitability before the risk gets really a lot higher over the 6 months. Secondly, it's very important that employers review and update their contracts and handbooks. These need to reflect the reduced qualifying period and the increased importance of probationary processes. So a very clear probationary period is essential, as Sam's already covered, but also following 6 months employment, you need to ensure that you have strong policies and that they are followed, such as, for example, conduct capability, not necessarily redundancy, but probably just with the conduct capability, potentially sickness processes. These should always be, we'd recommend it anyway, they should be based on the ACAS code of practice, and because employment tribunals take that into account. And I won't repeat that full guidance, but essentially you need to make sure you establish a fair reason for taking action or potentially dismissal. You must investigate thoroughly the issues to establish the facts. You must hold a disciplinary meeting or a capability meeting, and you should allow the right of appeal. And there's more to it than that, but if your processes are based on that, it puts you in a good position, hopefully, to defend claims, but it also potentially puts you in a better settlement position if you do need to look at trying to go down the amicable route, if you've got those procedures and you've followed them to get to a good open process. I've mentioned the risk of managers' capability, and I think manager training is critical within the next 6 months, but ideally sooner the better, I would suggest. So managers need to know when fair procedures are required, how early the risk arises, and how to document performance and conduct issues properly. Essentially, you would need to make very clear to managers about the probationary policies and procedures. Make sure they know how to document and where to document the probationary reviews, processes, concerns, and key dates really need to be recorded, because it's not a case now where you're thinking, oh, well, we've got a review meeting next week, we'll just delay it another month because it's not going to be a problem. It could be. So you need to have good diary management, make sure the reviews happen as they should, because any lapse on that, a first review could impact the second review, and then if you're over 6 months, you could be in trouble. So that needs to be in shape. I've already covered then the 4th box there, which is the approach to exits, particularly with senior staff. But I think that, as I said, and I do repeat it purposefully, I think the key would be to ensure that if you need to remove a senior employee and you want some leverage to do so, you need to make clear that you've got a strong open process and business case in place before you go down that settlement route. So you can say to that individual, there's a settlement offered, this is what we're doing. If you don't take it, we've got a fair process which we will follow. You're not going to get compensation at all, and even if you do, it'll be heavily limited. Ultimately, if there is no solid reason for taking such action or to fall back on, it may be difficult to encourage somebody, I suppose, to take that exit. Hence where the point comes in, maybe consider doing it now. And finally there, we've got staff audits. So staff audit and insurance review. The key point there is check your employment practices liability insurance and that they remain adequate in light of the uncapped compensation. Insurers must be mindful of this. They are probably making changes, but at the same time, it's quite a straightforward thing to check what your liability insurance is, check that it covers the changes. Probably premiums will go up because they always do anyway with insurance companies, but it's definitely worth checking. And so I think from my my sum up of my slides, and probably of everyone's really, is earlier intervention is better. Better documentation needs to be in place, and you need strong processes. And that is me finished. If we just go to the next slide, there is key actions, a roadmap, I should say, which you may want to just take a screenshot or a phone, a photo on your phone. It's just a whistle stop tour saying these are the changes, this is when they happen, just as by way of reference. But brilliant, thanks ever so much, everyone, for attending. I'll just hand you over to Sarah now and see if we've got any questions.
Yes, thank you ever so much, Mike. Yeah, we've left a couple of minutes at the end just for any questions, but I'm just having a quick look at the Q&A box and I can't see any questions have been submitted. But if you have got any questions, do feel free, drop us an email. The email address is there on the slide, or take a shot of the QR code. We'd be more than happy to follow up with you or arrange a telephone call. More than happy to sort that. I think all that remains is to say thank you for attending. Thank you to the team. It was really helpful and some practical tips there, and thank you to Keith and Dylan for sorting out the webinar and for allowing it to run very smoothly. Anyway, thank you so much. Bye bye.